Welcome back to LexTalks Legal Topics Simplified. Today we're diving into a world that's sometimes a little murky but always fascinating, the Negotiable Instruments Act of 1881. Specifically, we're going to be focusing on discharge from liability, material alteration, presentment, noting, and protest. It's like we're giving you a toolkit to navigate these essential financial documents.
That's a great way to put it. We're arming our listeners with the knowledge to understand how these instruments work, how to use them safely, and of course, legally.
Exactly. And I know the term negotiable instruments might sound a little intimidating to some of our student listeners out there, but they're really just formal documents that promise payment of money. You probably encounter them more often than you realize.
Absolutely. Think about the last time you deposited a check. That check is a prime example of a negotiable instrument, a document that represents a promise to pay a specific amount.
So it's not just about checks, right?
Not at all. We're also talking about promissory notes, basically a legally binding IOU, and bills of exchange, which are a bit more complex but commonly used in business,
Yeah.
especially international transactions.
Okay, that makes sense. But why should our student listeners care about these legal technicalities?
Because you see, these rules are like the guardrails on a highway. They exist to protect everyone involved, from individuals to businesses, and help ensure that these transactions happen smoothly and fairly. Imagine lending a friend money and getting a promissory note in return. If they decide not to pay up, you need a legal way to reclaim what's yours, right?
Right, so it's not just about understanding the instruments themselves, but also the laws that govern how they're used and enforced.
Exactly. And that's where concepts like discharge from liability come into play. Think of discharge like earning that coveted get-out-of-jail-free card in Monopoly, except in this case, it's a get-out-of-debt-free card.
I like that analogy. So
Okay.
how do you earn this get-out-of-debt-free card in the world of negotiable instruments?
The most common way is by payment in due course. This simply means the correct amount is paid to the right person at the right time, fulfilling the terms of the agreement.
Straightforward enough. What are some other ways to achieve discharge from liability?
Well, there's cancellation, where the holder of the instrument intentionally destroys it, basically saying this debt is forgiven. Imagine someone tearing up a promissory note right in front of you, signifying that the debt is no longer valid.
Wow, so it's literally like ripping up an IOU. So does that mean if someone tears up a promissory note in front of me, I'm completely off the hook?
In theory, yes. But to be extra safe, it's always wise to have all parties involved agree to the cancellation in writing. Think of it as documenting the get-out-of-debt-free card for future reference. This can help prevent any disagreements or confusion down the line.
That's a great tip. It's always better to be safe than sorry when it comes to legal matters. So we've covered payment and cancellation. Are there any other ways to achieve discharge?
Absolutely. There's also a formal release, where the holder of the instrument explicitly releases the obligated party from their duty to pay. This is basically a legal document stating that the debt is forgiven.
Okay, so it's all about clear communication and agreement between the parties, whether it's through payment,
Yeah.
cancellation, or a formal release. But what happens if someone tries to pull a fast one and changes the terms of the document without everyone's consent? And can someone just alter a check to say they owe more money?
That's where material alteration comes in, and it's a big deal. Any change that alters the legal effect of the instrument, like changing the amount on a check or the repayment date on a promissory note, can actually discharge the non-consenting parties from liability.
So if someone tries to be sneaky and change the terms without agreement, they actually end up weakening their own position.
Exactly. It's like shooting yourself in the foot, legally speaking. The law is designed to prevent fraud and protect the integrity of these instruments.
That makes sense. But what about less significant alterations? Like fixing a spelling error. Does that also discharge liability?
Great question. Minor changes that don't impact the agreement's core terms, like correcting a misspelling, are considered immaterial alterations and generally don't affect liability.
Okay, that's reassuring. But what if someone signs a blank check and then someone else fills it out for a much larger amount than intended? What happens in that situation?
Now, that's a tricky scenario. It can get complicated and often comes down to the specific details of the case. The court might consider the signer negligent for not taking precautions, but it also depends on whether the person filling out the check acted with fraudulent intent. These situations often require a legal expert to weigh in.
That's a good reminder to be extremely cautious when signing blank checks or leaving spaces on negotiable instruments. Always double-check everything before signing on the dotted line.
Absolutely. It's always better to err on the side of caution and make sure everything is crystal clear. And speaking of checking, that brings us to our next concept, presentment.
Okay, This is where things get really interesting. What does presentment actually mean in the context of negotiable instruments?
Well, imagine you're holding a bill of exchange, and it's time to collect. Presentment is the formal act of presenting that document to the person responsible for paying it. It's like knocking on their door and saying, hey, remember this agreement? It's time to settle up.
So you're literally showing up with the document and demanding payment.
That's the gist of it. But it's not just about showing up. Timing is also crucial. The law lays out specific time frames for presenting different instruments. For example, a check needs to be presented within a reasonable time, while a bill of exchange might have a more defined period.
So there are deadlines involved.
Definitely. And missing those deadlines can have consequences. If you don't present the instrument on time, and the other party suffers a loss because of it, you might lose some of your rights to claim the money.
Yikes. So procrastination can really backfire in this case.
It definitely can. However, there are also exceptions where presentment isn't strictly necessary, like when the obligated party has clearly stated they won't pay, or if they've become insolvent.
So there are some get-out-of-jail-free cards for presentment as well. But let's say you've done everything by the book, presented the instrument on time, and the other party still flat-out refuses to pay. What happens then? Is there any recourse?
That's where noting and protest come into the picture, and they add a layer of formality and legal weight to the situation.
Okay, those sound serious. What exactly do these terms mean?
Think of them as a way to officially document the refusal of payment. If a negotiable instrument is dishonored, meaning not paid or accepted when it should have been, it can be noted by a notary public.
So it's like getting an official stamp of disapproval.
You could say that. Noting provides legal proof that the instrument was presented and payment was refused. It's like having a witness testify to the fact that the debtor didn't hold up their end of the bargain. Protest takes it a step further. It's a more formal certified statement by the notary, carrying more weight, especially in international transactions.
So it's like saying, I'm not letting this slide. This is officially a problem, and I have the paperwork to prove it.
You got it. This process is especially important for international transactions, where you might be dealing with different legal systems.
Right. You need that extra layer of documentation to make sure everyone's on the same page, legally speaking. But let's bring it back to India for a moment. What about dishonored checks? I know bouncing a check here is a pretty big deal.
It certainly is. In India, issuing a check without having sufficient funds to cover it is actually a criminal offense. And the Negotiable Instruments Act has specific provisions to deal with this. It's not just about embarrassing. It can have serious legal consequences.
So before you write that check, make absolutely sure you have the funds to back it up.
Exactly. It's a good reminder to be responsible with your finances. And avoid finding yourself on the wrong side of the law. Plus, the law assumes that a check represents a valid debt, so the burden of proof falls on the check issuer to show otherwise.
That seems fair. You shouldn't be writing checks you can't honor in the first place. It all comes back to responsibility and transparency.
Precisely. The law is there to ensure that negotiable instruments are used responsibly, and that people fulfill their financial obligations.
Well, that's a lot to take in. It seems like the Negotiable Instruments Act is a pretty comprehensive piece of legislation, covering a wide range of instruments and scenarios.
It really is, and we've only just scratched the surface. There's a lot more to explore, like different types of negotiable instruments, the concept of holder in due course, and those all-important penalties for dishonoring checks.
I'm ready to dive deeper. Let's unpack some more of these fascinating concepts.
Let's do it. All right, let's shift our focus to some specific types of negotiable instruments covered by the Act. We've talked about checks, but there's a whole world of promissory notes and bills of exchange out there. They each have unique characteristics and play distinct roles in financial transactions.
Okay, color me intrigued. Tell me more about these intriguing financial instruments. I'm especially curious about promissory notes.
Imagine you borrow money from a friend, and to make it official, you write them a note promising to repay the amount on a specific date. That, in essence, is a promissory note. It's a legally binding IOU, a written promise to pay a specific sum of money to a specific person or the bearer of the note, meaning whoever holds it.
So it's like a formal IOU with added legal muscle. But what makes a promissory note legally valid? Does it need specific wording or formatting?
Good question. Promissory notes do have to follow certain rules to be legally enforceable. They must be in writing, contain an unconditional promise to pay, clearly state the amount owed, and specify the payee and the repayment date. No room for ambiguity there.
So it's all about clarity and precision. And what about bills of exchange? They sound a bit more complex, almost like a secret code from the financial world.
Well, they are a bit more involved than promissory notes. Imagine a scenario where you buy goods from a supplier overseas. Instead of sending cash directly, you might use a bill of exchange. It's essentially a written order from the drawer, instructing your bank, the drawee, to pay a specific amount to the supplier, the payee, either on demand or at a future date.
So instead of a direct promise to pay, it's more like a command. Pay this person this amount kind of instruction.
Precisely. It involves three parties. The drawer, the one issuing the order, the drawee, the one ordered to pay, and the payee, the recipient of the payment.
Okay, so it's like a financial relay race,
Yeah.
with the bill of exchange being the baton passed from one party to another. But why use a bill of exchange instead of a simpler promissory note or even a check? What's the advantage?
Great question. Bills of exchange are particularly popular in international trade. They offer more security and traceability than other methods. They can be endorsed, meaning signed over to multiple parties, creating a chain of responsibility and making them harder to forge or dispute.
Oh, that makes sense. They're like international financial travelers with their journey documented every step of the way. But with all these different negotiable instruments circulating, how can you be sure you're dealing with a legitimate one? Is there a way to protect yourself from potential scams or forgeries?
That's where the concept of holder in due course comes in. This is a crucial aspect of the Negotiable Instruments Act and provides essential protection for those who acquire instruments in good faith.
I've heard that term before, but never quite grasped its full meaning. Can you break it down for us?
Think of it like this. Let's say you buy a used car from a friend. You pay fair value, get the necessary paperwork, and have no reason to suspect anything shady. Later, you find out your friend didn't actually own the car, but you, as the innocent buyer, still get to keep it because you acted in good faith. Holder in due course is similar.
So it's like a legal shield for innocent parties.
Exactly. A holder in due course is someone who acquires a negotiable instrument honestly, for value, and without any knowledge of defects or previous claims against it. They are protected by the law and can enforce the instrument and receive payment, even if there were issues with the original transaction.
So even if the instrument was obtained through fraud or coercion, a holder in due course is shielded from those complications.
Precisely. They're considered a legitimate holder and can enforce the instrument as if they were the original payee. This encourages the free flow of negotiable instruments in the market, as people can acquire them with confidence knowing they are protected.
That's a really smart way to promote trust and stability in the financial system. It makes these instruments more reliable and encourages their use. But let's get back to the Act itself for a moment. You mentioned earlier that it has a whole chapter dedicated to the consequences of dishonored checks. That sounds pretty serious. Can you tell us more about that?
Absolutely. Chapter 7 of the Act specifically deals with the penalties for issuing a check without sufficient funds, commonly known as bouncing a check. In India, this is not just a financial mishap, but a criminal offense.
We know it can land you in hot water legally. But what exactly are the penalties involved? What kind of repercussions can you face?
The penalties can be quite severe, depending on the circumstances. They can include imprisonment for up to 2 years, a hefty fine of up to twice the amount of the check, or both.
Wow, that's a strong deterrent. It's definitely not something to take lightly.
Absolutely not. The law sends a clear message that dishonoring a check is a serious breach of trust and carries real consequences. It disrupts financial transactions, damages reputations, and undermines confidence in the system.
So what should someone do if they receive a bounced check? What are the steps to seek recourse?
The first step is to send a formal legal notice to the person who issued the check, the drawer, demanding payment. This notice gives them a grace period of 15 days to make good on the debt. If they fail to pay within that time frame, you can then file a criminal complaint against them.
Okay, so there's a clear legal process to follow. It's not just a matter of getting angry or frustrated. You have to take specific legal steps to protect your rights.
Exactly. It's crucial to follow the proper procedures to ensure your claim is valid and enforceable. And remember, the courts in India take these cases seriously, recognizing the impact bounce checks have on the economy and individual financial well-being.
So to recap, the Negotiable Instruments Act covers a wide range of instruments, from checks and promissory notes to bills of exchange. It protects the rights of all parties involved, from the drawer to the payee to the holder in due course.
Precisely. It provides a comprehensive framework for how these instruments should be created, used, and enforced, ensuring a degree of clarity and predictability in financial transactions.
It defines key concepts like holder in due course and outlines the penalties for dishonoring checks, making it clear that financial responsibility is paramount.
And it has been amended over the years to keep pace with the evolving financial landscape, ensuring its relevance in today's world.
But I'm sure there are still some gray areas and tricky situations that come up in practice. The law can't possibly anticipate every scenario, right?
You're absolutely right. There are always nuances and complexities that arise. For example, we talked about material alteration. But what constitutes a material alteration can sometimes be a matter of debate, depending on the specific circumstances.
Like the example we discussed earlier, where someone
Mhm.
signs a blank check and someone else fills it out for a much larger amount. That's a classic case where the lines can get blurry, right?
Exactly. And there are countless case laws and legal interpretations that have emerged over the years, shaping how the act is applied in real-world situations.
Well, that's what makes law so fascinating. It's not just a set of rigid rules, it's a living, breathing system that adapts to new challenges and interpretations.
You got it. And for our student listeners who are just embarking on their legal journey, I encourage you to delve deeper into this act. Explore case laws, read legal commentaries, and don't hesitate to ask questions.
Great advice. The more you learn about the Negotiable Instruments Act, the better equipped you'll be to navigate the complexities of financial transactions and protect your interests.
And who knows, maybe one day you'll be the one arguing a landmark case before the Supreme Court, shaping the future of negotiable instruments law.
Now, that's an inspiring thought. But before we get too carried away, let's get back to the core of the Act. We've covered a lot of ground, but there are still some key concepts we need to unpack, like the various ways liability can be discharged. We touched on it briefly, but it's such a fundamental aspect that it deserves a closer look.
I agree. Understanding how discharge from liability works is essential for anyone dealing with negotiable instruments. It's like knowing the rules of the game to avoid any pitfalls.
Okay, so we know that discharge from liability essentially means a party is no longer legally obligated to pay on the instrument. But how exactly does this happen? What are the different pathways to achieve this get-out-of-debt-free status, so to speak?
Well, as we discussed earlier, the most straightforward way is through payment in due course. When the instrument is paid according to its terms, all obligations are fulfilled, and the liability is extinguished. It's a clean and simple resolution.
Okay, that makes sense. It's the ideal scenario, everyone fulfilling their end of the bargain. But what about other situations where things might not be so straightforward? Are there other avenues for discharge?
Absolutely. Cancellation is another way,
That
and it relies on the intent of the holder. If the holder of the instrument decides to forgive the debt and intentionally cancels the instrument, let's say by physically destroying it or marking it canceled, the liability of all parties is discharged.
So if I'm holding a promissory note and I choose to forgive the debt, I can just tear it up. And that's the end of it.
Mm.
No more obligation.
In theory, yes. But as always, it's best to get written confirmation from all parties involved, acknowledging their agreement to the cancellation. This can prevent any future disputes or claims arising from the canceled instrument.
Good point. It's always wise to have a paper trail when dealing with legal matters, especially when it comes to financial obligations. But what about situations where the instrument itself goes missing? Let's say a promissory note is lost or accidentally destroyed. Does that automatically discharge liability?
That's an interesting question. The loss or destruction of the instrument itself doesn't automatically discharge liability. The party who is obligated to pay might still be required to honor the debt. However, they need protection from potential claims arising from the lost instrument, like someone finding it and trying to enforce it.
That makes sense. You wouldn't want to end up paying twice for the same debt. So how does the law handle these situations?
The law provides a mechanism called indemnity for such cases. The party who lost the instrument can provide an indemnity bond to the other party, promising to compensate them if any claims arise from the lost instrument.
So it's like an insurance policy against potential double trouble.
Exactly. It safeguards both parties. The payer is protected from multiple claims. And the holder, even though they lost the physical instrument, is assured they won't lose their right to the debt.
Okay, so we've covered payment cancellation and what to do if the instrument is lost. Are there any other ways liability can be discharged? Maybe something that happens automatically, without the parties taking specific actions?
Yes. There's a concept called discharge by operation of law, which covers situations where the law itself extinguishes the liability, even without explicit action by the parties.
That sounds intriguing.
Hmm.
Can you give us some examples of how this operation of law magic works?
Sure. One example is when the holder of the instrument becomes the person liable to pay on it. Let's say you're the payee of a promissory note, but circumstances change, and you later become the maker of the note. In this case, your liability would be discharged because you can't owe money to yourself.
Interesting. So it's like a legal paradox. The debt simply dissolves because the roles have reversed.
Precisely. Another example is when the debt becomes barred by limitation. meaning there's a time limit for taking legal action to enforce a debt. If the holder misses this deadline, their right to claim the money is extinguished by the operation of law.
So in some cases, procrastination can actually work in your favor.
Well, not exactly. It's never advisable to rely on limitation to get out of a debt. It's always better to address financial obligations promptly and responsibly.
Wise words. So we've covered payment cancellation loss and indemnity and discharge by operation of law. Are there any other scenarios we should be aware of when it comes to discharging liability?
Yes. There's one more concept we touched upon earlier. Discharge by material alteration. Remember, if a significant alteration is made to a negotiable instrument without the consent of all parties involved, the liability of the non-consenting parties is discharged.
So if someone tries to tamper with a check, let's say by changing the amount without my knowledge, they essentially void the check, at least as far as I'm concerned.
Right. That's right. The law recognizes the potential for fraud and abuse with alterations, so it provides this protection to ensure the integrity of the instrument.
Makes sense. It all comes back to maintaining trust and fairness in financial transactions.
Precisely. And remember, this discharge only applies to those who did not consent to the alteration. The person who made the alteration and anyone who benefited from it would still be liable.
So if you're thinking of getting creative with a negotiable instrument, think again. The law is on the side of those who act honestly and in good faith.
Absolutely. The Negotiable Instruments Act is a robust piece of legislation that aims to ensure fairness, transparency, and accountability in all transactions involving these financial instruments.
It's like a roadmap for navigating the world of bills of exchange, promissory notes, and checks, helping us understand the rules of the road and avoid any legal potholes along the way.
Exactly. And for our student listeners, I encourage you to continue exploring this act. It's full of fascinating concepts and real-world applications that can be incredibly valuable as you embark on your legal careers.
Great advice. And who knows, maybe one day you'll be the legal experts guiding others through the intricacies of negotiable instruments law.
Now, that's a goal worth striving for. But for now, let's shift our focus to another important aspect of the Negotiable Instruments Act. Remember our discussion about presentment. It's not just about physically handing over the instrument. There's a whole legal framework that governs this process, ensuring fairness and protecting the rights of all parties involved.
Okay, I'm ready to dive deeper into presentment. We touched on the basics, but I'm eager to explore its nuances and understand its legal significance. All right, let's unravel this concept of presentment. It sounds straightforward enough. You present the instrument to the person who needs to pay, but I have a feeling there's more to it than meets the eye.
You're absolutely right. Presentment is more than just handing over a piece of paper. It's a formal, legally significant act with specific rules and implications.
Okay, so let's break it down. What exactly constitutes presentment in the legal sense?
Imagine you're holding a promissory note that's due for payment. Presentment is the act of formally presenting that note to the maker, the person who promised to pay. It's like saying, hey, remember this agreement? It's time to make good on your promise.
So it's a way to officially demand payment and set the wheels in motion.
Exactly. It's a crucial step that triggers the payment process and establishes a clear timeline for when the payment is due. It's like serving a legal notice, but in a more structured and formal way.
That makes sense. But why is presentment so important from a legal perspective? Why not just hold on to the instrument and wait for the payment?
Well, presentment serves several crucial purposes. Firstly, it protects the rights of the holder of the instrument. If you don't present the instrument within a reasonable time frame, you might lose certain rights, like the right to claim interest, or even the right to take legal action against other parties involved in the transaction.
So procrastination could actually cost you money. It's not just about missing a deadline. It could impact your legal standing.
Precisely. Delaying presentment can weaken your position and make it harder to enforce your rights. On the flip side, presentment also protects the party who's obligated to pay. It gives them a chance to examine the instrument, ensure it's authentic and hasn't been tampered with, and verify they have the funds to make the payment.
So it's a two-way street. It protects both the holder and the payer, creating a fair and transparent process for everyone involved.
Exactly. It ensures accountability and provides a clear framework for resolving any disputes that might arise.
Okay, that clarifies things. But you mentioned presenting the instrument within a reasonable time. What exactly constitutes a reasonable time in this context? Is there a fixed deadline, or is it more flexible?
That's a great question, and it's one that often sparks debate in legal circles. Reasonable time isn't explicitly defined in the Negotiable Instruments Act, so it's open to interpretation, based on the specific facts and circumstances of each case.
So it's a bit of a judgment call?
You could say that. Courts will consider factors like the type of instrument involved, The nature of the underlying transaction, the usual course of dealings between the parties, and any specific instructions or agreements regarding presentment?
So there's no one-size-fits-all answer. It's all about context.
Exactly. Flexibility is key here. But even though reasonable time is somewhat open to interpretation, it's crucial to remember that unnecessary delays can have consequences.
Right. We've already established that procrastination isn't your friend when it comes to negotiable instruments. But let's say you've done everything by the book, presented the instrument on time, and for some reason the payer refuses to honor their obligation. What happens then?
That's when things can get a bit more complicated. But the law provides avenues for recourse. If the instrument is dishonored, meaning the payment is refused, the holder can take steps like sending a formal legal notice demanding payment.
It's like a final warning shot. You've had your chance. Now it's time to pay up.
Exactly. And if that doesn't work, the holder might have to consider more serious legal action, like filing a civil suit to recover the amount owed, along with any associated costs like interest and legal fees.
So it's off to court to settle the dispute. I imagine these cases can get pretty complex, especially if there are disagreements about the validity of the instrument or the amount owed.
They certainly can. That's where having a knowledgeable lawyer by your side can make all the difference. A skilled lawyer can help you navigate the legal procedures, build a strong case, and hopefully secure a favorable outcome.
Sound advice. So for our student listeners who aspire to be legal eagles, this is definitely an area of law where you could really make a difference, helping people understand their rights
Yeah,
and navigate these complexities.
absolutely. The Negotiable Instruments Act is woven into the fabric of our financial system, impacting countless transactions every day. Understanding its nuances can be a valuable asset for any lawyer.
Well, we've covered an impressive amount of ground today, from discharge of liability to material alteration to presentment and dishonor. I feel like I've gained a much deeper understanding of this fascinating area of law.
It's been a great discussion, and I'm glad we could shed some light on this important topic.
I'm sure our listeners have learned a lot as well. So to wrap things up, any final words of wisdom for our student audience?
Just remember that this deep dive was merely an introduction. The Negotiable Instruments Act is a complex piece of legislation with layers of detail and legal precedent, so keep exploring, keep asking questions, and never stop learning. The legal world is full of exciting challenges and opportunities for those willing to delve deeper.
Perfectly said. Thanks for joining us on LexTalks Legal Topics Simplified. Subscribe for more beginner-friendly episodes.